afternoon, or evening, wherever you are. I'd like to welcome you to panel 3, the final panel on climate justice of the ILA Caribbean Branch Conference, themed Justice and Resilience for the Caribbean, What Role for International Law? My name is Alana Lancaster, and I'm an environmental and energy lawyer, specializing in the marine environment, and I'm also a member of the ILA Caribbean Branch. Before we begin, I'll do some housekeeping, and then I'll introduce our panel. So all sessions will auto-record, which we will upload to our YouTube channel after the event. So, you know, if persons miss it or you want to recommend persons to see the panels, including those that of this morning, please feel free to do so. Please use the chat function to introduce yourselves, but use the question and answer function to ask questions to the panelists. If you have a question directed at a specific panelist, perhaps you can preface or put in brackets which panelist you're directing the question to. So a little bit about the inspiration for today's panel. It's no secret that climate change is irrefutably a global problem of international scope. To quote UN Secretary General Antonio Guterres, climate change is happening now, and it's happening to all of us. No country or community is immune, and as is always the case, the poor and vulnerable are the first to suffer and the worst hit. These sentiments are reinforced by the Caribbean region's own Mia Motley, the Honorable Prime Minister of Barbados, who recently concluded the 76th UN General Assembly by emphatically making the point that there is need for a COVID-19 vaccine, equity, and climate justice. Invoking Bob Marley's famous song, Get Up, Stand Up, in her speech, Motley made the argument in favor of bringing climate justice ahead of COP26, which will be the largest and most highly anticipated meeting on the issue of climate, which occurs in a mere 2 weeks. She posited the question, who will get up and stand up for the rights of our people? And by our people, she was referencing to the persons in small island and developing states. Now, climate justice is nested within the idea that the adverse impacts of a warming climate are not felt equitably among people, and acknowledges that climate change can have different social, economic, public health, and other adverse impacts upon underprivileged populations. Advocates for climate justice are striving to have these inequities addressed head-on through long-term mitigation and adaptation strategies. As the IPCC's, the Intergovernmental Panel on Climate Change's 6th assessment report, published in August 2001, steadfastly and somberly illustrates, these impacts, as the climate change impacts accelerate, extreme weather events are taking a major toll on developing countries, particularly in the Caribbean, the Pacific region, Asia, which are homes to some of the world's largest youth populations. Climate justice, therefore, raises questions of human rights, intergenerational equity, distributional, and procedural justice. We meet today in perhaps an era of tremendous promise. As just 2 weeks ago, we have seen the UN Human Rights Council recognize the right to a safe, clean, healthy, and sustainable environment is essential to the fulfillment of other human rights. It was also accompanied by the newly minted decision to create a special rapporteur on human rights and climate change, as well as the decision by the CHR. These are also reinforced in the Latin American Caribbean region by the entry of force in 2021, April 2021, of the Escazú Agreement. The aim of today's panel, therefore, will explore the role of international law in securing climate justice for the Caribbean, one of the most vulnerable regions to face the impacts of climate change. Today, our panelists will explore the prospects and challenges of using international treaty regimes, climate-based litigations by both state and non-state actors, as well as emerging principles of international law. Join me in welcoming our panelists and our rapporteur, Mr. Stefan Newton of the ILA Caribbean Branch. I will now have each panelist introduce themselves before we dive into the panel discussion. Rueanna?
Alana. Hi, everybody. I'm actually in the UK already, ahead of COP26. I'll be taking a train from London to Glasgow on the 26th to the beginning of the pre-sessional meeting before the conference itself starts on the 1st of November. Apologies, I'm in a Starbucks, so there'll be quite a bit of background noise here. It's Saturday evening, people are out on the bus. So my name is Rueanna Haynes, as Alana would have mentioned. I am, a climate law and governance specialist, former Trinidad and Tobago diplomat. I served at the Permanent Mission of the United Nations in New York, Permanent Mission of Trinidad and Tobago in New York from 2010 to 2016. During that time, I worked on climate as well as sustainable development issues. So we were working on the development of the Sustainable Development Goals and Agenda 2030. At the same time, we were developing the Paris Agreement. In the climate context, I served as a lead negotiator for the Alliance of Small Island States across a number of different issues. My current role is as the lead negotiator for AOSIS on transparency. We're still settling issues in relation to the enhanced transparency framework of the agreement. I, at present, working with a not-for-profit organization called Climate Analytics that's headquartered in Berlin, and we recently opened an office in Trinidad and Tobago. That's it from me. Thanks.
Oh, Conway.
Hi, everyone. My name is Conway Blake. I'm a litigator and international lawyer. I'm in private practice in the UK. My area of specialization is largely public international law disputes, whether before the ICJ, the various regional human rights bodies, and commercial disputes in international arbitration and other such fora. And I'm increasingly seeing climate change justice seeping into international dispute resolution, both at the interstate level, but also in disputes between states and with private entities. And so I'm really pleased to join everyone here to speak about the role of international law and climate justice, because I think this is a very important issue, not only on the world stage, but particularly for those of us who reside and live in the Caribbean Basin. Thank you.
Justin.
Hello, everyone. My name is Justin Sobion. I'm an attorney at law by profession, well, specializing in international law. And I've been involved in litigation. Well, I started off in private practice, and then I joined the Ministry of Foreign Affairs. That's where I met Rueanna. She was posted to the New York mission, and I was posted to the Geneva mission. And I worked as a diplomat for my country at the United Nations for 6-7 years. Well, actually almost 10 years, because after that I was working with the UN Human Rights Council, the president of the UN Human Rights Council. And now I'm in New Zealand, working for the last almost 3 years, 2.5 years now, working on my PhD on environmental law and ecological law, which I prefer to call it, because for me, as the trend, as we hit into the 21st century, is getting more broader than environmental law, but ecological law. And the focus of my work is on the rights of nature and earth trusteeship, which you will hear some more about. Thank you.
And last but not least, Lisa.
Good morning, or good afternoon, or good evening. Alana, it's great to see you and all my colleagues in the region. I'm Lisa Benjamin. I'm an assistant professor at Lewis and Clark Law School in Portland, Oregon, where I teach international climate change, energy resources and policy, environmental justice, and administrative law. I'm from the Bahamas, and I taught at the University of the Bahamas for 10 years. And during that time, I provided legal support to the Bahamian delegation to the UNFCCC negotiations, including the Paris Agreement, where Rueanna and I were helping to advance the role of AOSIS at different levels in the negotiations. I am still a member of the UNFCCC Compliance Committee on the Facilitated Branch. I've been there for 7, almost 8 years now. And I am also an expert reviewer for the Race to Zero, which is a UN-backed campaign to try to get non-state actors, cities, sub-state actors to commit to net zero emissions reductions by 2050. I also co-chair the Climate Accountability Research Group at the Climate Social Science Network.
Thank you, everyone. So without further ado, we're going to begin our discussion. So I first turn to Rueanna. Apologies, Rueanna. My tongue's getting a bit tight. And I think the first place we want to begin is to kind of frame what climate justice is. So Rueanna, you've been involved, as you mentioned, you've been involved in climate negotiations at a multilateral level, and you've also been involved from the level of civil society, if you so to speak. Can you give us a picture of what is meant by the term climate justice, and perhaps what this approach would mean for a region such as the Caribbean region?
Thanks, Alana. So I'll start by highlighting 4 aspects of climate justice that I have observed so far when people refer to the term. I'll start off by saying that in my view, there isn't really a coherent definition of the term climate justice. I hear it being used in a number of different contexts to refer to different things. And some of these contexts tend to also be in opposition to each other. So there is some reconciling that needs to take place. So the 4 aspects I want to discuss would be, first of all, the international aspect. And I think this aspect is perhaps quite well understood, especially in the sense of the global climate discussion. So when we speak about the role of vulnerable countries, for example, so I speak on behalf of the Alliance of Small Island States. The AOSIS is called frequently the conscience of the convention. And that is because the primary argument that we bring forward is that, here's a group of states that is least responsible for the climate crisis, but which is suffering the most from its impacts. So the question around climate justice in that context then comes down to, the global community showing solidarity with vulnerable countries in terms of helping them to cope with climate impacts, but also in terms of taking measures to ensure that the impacts of climate change can be mitigated. And this idea of solidarity, this idea of climate justice on a grand sort of very international scale, as in between states, is one that plays out in various ways in the discussion. So there's the finance angle, but there's also the issue of loss and damage, which Lisa is going to touch on as well, and the question around, what is owed to these vulnerable countries based on what they are suffering. The second aspect I want to talk about is the domestic one, which I think is gaining traction. So when we speak about climate justice in a domestic sense, from what I've heard from the discussion, it has a lot to do with the question of state responsibility and human rights. What is the responsibility of governments to help their own people in particular the vulnerable within their own context, within their own society, as it relates to climate change and the impacts that they are facing. So this also raises questions around a just transition and what that means in particular to the workforce. Even within the region at this point, there is a lot of discussion amongst labor organizations, for example, unions, and this question around tackling this question of climate justice and what is owed to them as individuals that may be disadvantaged by progressive action taken by governments to address climate change. So there's the mitigation side of it that triggers the just transition question, but then there's also the adaptation side of it, looking at vulnerable communities, displacement of these communities. When we consider sea level rise, when we consider extreme events, the question is, what is owed by government to the people that will be suffering these impacts and will continue to suffer these impacts as climate change ramps up. Third aspect I wanted to discuss is the question is intergenerational. So the question around intergenerational equity and where and how climate justice comes into play as can be seen current generation and future generations. For the current generation and younger generations that are coming up, we've seen a lot of this playing out very recently in the past few years, since 2018, with the school strike, the Fridays for Future movements, where young people are stepping up, young people are, leading in litigation against governments, informing a lot of the briefs that are being written on this. And I imagine Conway will touch on this in his presentation as well. And then the last aspect I want to address has to do with this question of actors. And I haven't heard much about climate justice in this context, but as we're in the framework of an international law discussion, what I would want to put forward is this. We understand that nation states have the primary responsibility for addressing the climate crisis. They have the primary responsibility to their own populations in particular. We understand that the policies that they set is what will drive action on climate change. But we also understand that a lot of the actors that have to be moved on this question are actually non-governmental. They are private, they are corporations, they are big business, they are multinationals, and they do not owe any duty of care to anybody. And so there's this question around climate justice that comes in here in terms of what is their role. A number of them have been taking on long-term targets, various climate targets that have been regarded as greenwashing. There's the whole campaign around Exxon New, because a lot of these companies have known for a very long time that their activities are actually driving the climate crisis. A lot of these multinational companies have, bottom line profit margins that are larger than the GDP of many countries in the Caribbean. They control where the resources go. And so the question arises, what is their role in this question of understanding climate justice? We have developed a whole branch of international law in terms of investment law that allows them to hold governments accountable for affecting their bottom lines with government policy. But there is no corresponding development to be holding them accountable. That is a question that I would ask you, and I know that there are specialists on the panel who can respond to it. So I'll probably just wrap up by making final 3 points. The first is, since many of the needs of the vulnerable groups that we speak about in the context of climate justice may not be in line or may in fact be opposing, how do we reconcile these needs? There are trade-offs that need to be made in how we understand climate justice for whom, at what point in time. And this draws very much on the debate around the just transition and what it requires, as well as on the question of corporate accountability. And finally, I guess for me, I have an enduring question around how are we going to pull these different elements together. Climate justice now is the catchword of the moment. I mean, it's very, very slowly and quickly gaining traction in the global climate discussion. But of course, it can be used both as a weapon and a shield by different people, different entities for different purposes. So I would say for us in the Caribbean context, we need to very quickly understand what this means from a citizen perspective, from a government perspective, and be able to push that forward both at the domestic and regional level as well as at the international level. Sorry for the background noise. Thank you.
Thank you so much, Rueanna, for that very comprehensive, as well as you've left us, including myself, with a lot of food for thought. And I like what you kind of ended off on the, and I think this was a question, something posed in the health resilience panel. Is it the issue of sword versus shield, international law being a sword or a shield? Lisa, I like to turn the discussion to you as we're looking at the international regime as it relates international law. Let's talk a bit about some of the challenges of using international regimes. I think Rueanna alluded to some of the challenges. We in the Caribbean certainly have made a lot of the Paris Agreement. Does the agreement hold as much promise for regions such as the Caribbean region as much as we hope it does?
It's a good question. I had very mixed feelings at the end of the negotiations for the Paris Agreement. I have to say I was bitterly disappointed because I felt like there weren't stringent obligations of result. And by that, I mean parties have obligations of conduct under the Paris Agreement. They have to submit nationally determined contributions to say what they're going to do. But the language about making them actually achieve those is very, very weak. And so I was disappointed at the end of the Paris Agreement, but I've come to love the Paris Agreement over time. And the reason I've come to love it is for several reasons. One, I had to get over that disappointment and realize it was just not politically feasible. Two, there's some really good parts of the Paris Agreement. The first is that it could never have happened. Right? We were stuck for a long time with the Kyoto Protocol and we were at a roadblock internationally and there had been collapse negotiations before. So there is a distinct possibility that this may not have happened. Two, it is a binding legal treaty. It has provisions in it which are binding and other provisions which are much more soft law provisions, have varying levels of bindingness. And the reason for that is because developed and developing countries had to come to consensus about what they wanted to do. And I think the third part about it that's really good is it provides a solid framework going forward, which allows and in fact encourages through soft law mechanisms parties to what we call ratchet up their ambition in their nationally determined contributions. And so it has the potential to provide justice for the Caribbean. In addition, and importantly, it provides a provision which is separate and apart from the provisional adaptation on loss and damage, which I can talk about a little bit. So I think there are some fairly good things about the Paris Agreement, but I think we have, and also it has been picked up in litigation around the world. Surprising to me, lots of courts in different countries have actually used the Paris Agreement as a justification for finding outcomes which are very progressive. And so it has been very useful in that sense, as well as for some non-state actors. The bad part about the Paris Agreement is that countries themselves have not taken up that opportunity to advance their national goals. And so while it is bottom up, we need countries to participate and become ambitious. And so there has been a recent synthesis report by the Secretariat of the UNFCCC, which synthesizes NDCs that have been submitted, I think, by July of this year. And that shows us very clearly that we are not on track for the global temperature goals in the Paris Agreement, which were also really good provisions that AOS has fought long and hard for, including around loss and damage. And the global temperature goal, the aspirational goal to keep increases under 1.5. We know that even 1.5 is not safe for the region, and in fact, 1 is not safe for the region. And it looks like with this synthesis report, we are not on track. And in fact, we could possibly exceed 1.5 in the very near future, and that would be extremely bad news for the Caribbean. So I have mixed feelings about the Paris Agreement. It has potential, but it's up to parties, right? Particularly those
Yeah.
large developed and developing countries to take action.
Yeah, definitely. I think I myself have mixed views, but as you said, I guess it was better than the gridlock we were in. One of the things I picked up on in what you were saying just now, and I think it's very relevant for countries, AOSIS and small island developing countries such as this, and I know you're currently conducting research on this, is the concept of loss and damage in relation to the climate change regime. In simple terms, what do we mean when we say loss and damage in the international law context, and how does that relate to this entire theme of climate justice?
So traditionally, we had two main concepts: mitigation, which is reducing your emissions, and adaptation, which is where you have to actually adapt to and change in order to deal with the impacts of climate change. And what we were finding in the Caribbean and in Pacific Island states is that there were impacts of climate change that we could not adapt to. And that's where the concept was developed, particularly within AOSIS negotiators, of the concept of loss and damage. And those are impacts that you just cannot adapt to. They go beyond the limits of your adaptation. There's two parts to L&D. One is loss, and that idea is permanent and irreversible loss. And so, for example, if coral reefs in the region bleach because of warm water temperatures, they die, that's irrecoverable. You just can't get that back. Same with freshwater lenses. If they're penetrated by salt water, you lose that freshwater lens. You just can't get that back. You can't adapt to that. The other part of that is damage, where there are impacts that are just financially and technologically really expensive for you to recover from, and therefore they are just beyond the capacities that you have as a small island state to adapt to. And so AOSIS negotiators worked really hard to get this concept of loss and damage understood. There is no one set uniform definition of it. And so within the international negotiations, the idea is that there's this constructive ambiguity that might be helpful to allow parties to actually have a provision on loss and damage, which again, AOSIS fought long and hard for. So Article 8 in the Paris Agreement commits parties to minimize, avert, and address the loss and damage. So it's anchored in a treaty separate and apart from adaptation, which was really important for small island states to do. It's also important to recognize that even before the Paris Agreement, there was the Warsaw International Mechanism, which dealt with loss and damage. And so there was a framework that existed. But it was really important to get that Article 8 in the Paris Agreement, and countries have been working really hard to try to continue to explore basically the three elements of the Warsaw International Mechanism. A corollary to Article 8, I have to mention, in the COP decision, which accompanied the Paris Agreement, has a provision that says Article 8 in the Paris Agreement is not a basis for compensation or liability, which was an important corollary that developed countries wanted in order to agree to have Article 8 in the Paris Agreement at all.
Thank you, and I think we're gonna get to some of discussing some of loss and liability. Sorry, the aspect of liability shortly when we speak with Conway. But so we spoke about events, events which cause loss and damage. I think you alluded to the fact that the Caribbean is vulnerable to some of these events. And my understanding is that they are longer term as well as slow onset events, slow onset as opposed to extreme events. Can you give me some examples within the context of the Caribbean region? And yeah, well, let me start with that, and then because I just had another thought which would follow on.
Yeah, so I think in the Caribbean, what we have been seeing is really intense and more intense hurricanes, which lead to more storm surges, more flooding, more frequency of these extreme events like hurricanes. And so, for example, in the Bahamas, we had Hurricane Dorian, that's one of the most powerful storms that we have ever experienced in that country. And so what happened is Bahamians basically the storm surge was so high, they were washed out of their homes. Bodies were never found. People had to bury empty coffins. The grief of that was tremendous. And so it was just something that you just can't adapt to that. You just can't deal with that. And then, of course, what it does is lead to this concept that my co-author Adele Thomas and I have talked about, this unvirtuous cycle of loss and damage. So you have countries like Caribbean states that have really small human populations, limited human capacities, small public budgets, which are under strain from debt. You have an extreme event like a hurricane, people have to take from those public budgets or incur more debt to be able to actually pay to recover from this hurricane. That leaves less public money and more debt, and therefore more capacity constraints. And so what happens is these events that we are experiencing are rolling back really important development gains. So some of that public budget would have been allocated for climate change adaptation, for example. We just have to use that to recover, and therefore we can never actually improve our resilience and reduce our vulnerability in advance. And so the idea that SIDS are arguing for is this concept of multi-dimensional vulnerability, to be able to look at things like the impact of COVID and extreme events and debt, and really think about how this affects us holistically in terms of developments of countries. And one of the concepts in loss and damage is that it impacts it causes intolerable risks. These are risks that affect the health, the welfare, the lives of Caribbean citizens, and they are just something that we just cannot adapt to.
Thank you, Lisa. Well, two things that come to mind as you were given the example. The first is that when you speak of irreparable loss, there's the synergy between obviously these challenges and the other large environmental issue of our day, that of biodiversity loss. But what I think more than that is perhaps most troubling for our region is that, and this will segue beautifully into our discussion with Conway. More and more in the Caribbean, we're seeing the issue of which is phrased internationally as climate-induced migration. That is, you have some extreme event, for example. So, for example, in your native Bahamas, we've seen it in 2019 with Hurricane Dorian, in 2017 with Maria in the Commonwealth of Dominica, and of course Barbuda, where entire islands were affected, or parts of an island chain. And as we experience stronger and stronger hurricanes, this could be a reality. And indeed, this is an issue that the UN Human Rights Council has examined in relation to Pacific SIDS, and seemingly opened the door to climate crisis change. Do you think that these developments are a reason to be optimistic, or should we still remain cautious about the role which international law can offer in terms of solutions for regions such as the Caribbean and Pacific SIDS and AOSIS, I suppose?
I think the first thing to say for climate-induced migration and displacement, it's a hugely sensitive issue. Most Caribbean nationals and Pacific nationals don't want to move. Most countries don't want to have a migration policy, even within migration within country, which will be the first step for countries that have land and space that are safe for people to move to. That's a hugely difficult discussion to have with your own population. It's difficult to ask governments to engage in this conversation, particularly when they are certainly not to blame for this. In addition, it's the most vulnerable constituents that are affected. And so I did some research with Adele Thomas. We looked at Ragged Island, which is an island in the Bahamas, which the whole island had to be evacuated because of a hurricane. And that's a very small community of a couple hundred people. And after the event, the government picked them up in the national Bahamas Air and moved them to the capital. And after the hurricane, basically the financial institutions told the government of the Bahamas, we're not lending money to you to rebuild this community. We don't think it's worth it, which left the government in a terrible position because they had to tell residents, sorry, you can't move back home. We're not going to fund this. And the residents were so attached to their sense of community and place, which is the idea of non-economic loss and damage. That's cultural attachments to community, that they themselves raised money to get a freshwater desalination plant, to rebuild the police station, rebuild the clinic, rebuild their houses. And so this idea of cultural attachment tells us that in the Caribbean and in the Pacific, we need to consult with communities, particularly vulnerable communities, to ask them their inputs. We need data. There's a huge lack of data in the region about where we should move people to, what is the most vulnerable spots and what are not. We can't get financing for data collection ever from international financial institutions and grants. And so we really need to focus on vulnerable communities. And then in the Pacific, there was this appeal by a national of Kiribati to ask the Human Rights Council to overrule the New Zealand decision, which refused him refugee status. And he argued that the lack of ability to grow crops because of salination of soil, the overcrowding in the capital because of loss of land due to slow onset events, the violence that he was worried about, the having to rebuild seawalls, all of these impacts were meant that he could no longer have a life of dignity in Kiribati. And the Human Rights Council, it's a sort of a split decision. They open the door, as you said, to say that it's possible that some of these impacts could affect fundamental human rights, which could lead to him being classed as a refugee. The problem with that definition is you need to be in imminent and real risk of harm. And they found that he was not within the next decade any more at risk than all the nationals of Kiribati, which tells you the bad news is that, you know, it's bad. I mean, if you read the decision, it's pretty sad what he's facing. And so the council said, you know, there's another good 10 to 15 years that the country could actually, with international help, try to adapt. And that puts the burden on us to do something about it, which is really violates the sort of first category of climate justice that Rue talked about. So it's sort of a good and bad decision, but it does tell you that a lot of countries and nationals are already at crisis point, and we are only at about a 1 degree temperature rise at the moment. So.
Thank you so much, Lisa. So I think it does give us quite a bit to think about, because while there's been a lot of judicial activism, I suppose, in regard to climate migration and the link between climate change and international dispute settlement in the Pacific region, if we look at a lot of decisions, indeed, including this week's decision from the Council of Human Rights, there are glimmers of hope, but still not quite, I suppose, climate, you know, what we'd want as I suppose the states most disproportionately affected. I want to turn to Conway right now, because we can nicely segue into a discussion on you know, the increased attention in international dispute settlement processes. But before I get into that, I'll just remind the audience that you can pose your questions in the Q&A. We'll get to them in a bit. And also, if you have a specific question, of course, please indicate who you want to ask this question to. Right. So Conway, yeah. So as Lisa alluded to, there's been an increase in the attention, and you indeed in your introduction, when you introduced yourself, it indicated that this settlement processes at the international, and I dare say maybe even at the regional and national level, there's been increasing attention in the potential nexus between rights, obligations, responsibilities and liabilities of states, and I suppose other non-state actors, for perhaps if you term it the impacts of climate change broadly. now, many of these efforts have, as I said, been at the national and regional level, but many have their limitations or may have their limitations. Can you tell us a bit about how do you see this as an international lawyer? How do you see this linkage unfolding? Is there a cause for glimmers of hope or cautiousness? And what were maybe some of the reasons for this? Sorry, I hope I haven't packed too many questions in there.
I know. I think I'll try to at least answer some of it. You could tell me if I haven't. So you are right. There has been in the last 5 years, certainly in the last decade, but certainly in the last 5 years, an increase in climate change litigation, both at the domestic, regional, and well, mainly at the domestic regional level. But increasingly, there are signals that people want to have this climate change issue litigated internationally. We see, for example, various aspects of climate justice being brought to the courts. Lisa just spoke about the whole question of refugee status and migration, but we see, for example, the more the use of, for example, the European Convention on Human Rights in the Netherlands, where the court found in 2 decisions, actually, that's very interesting. One, and the decision in the case called Urgenda, which was a case brought by individuals against the Dutch government, trying to keep the Dutch government in compliance with its climate change emission standards, that it wasn't doing enough to meet the standards that it had signed up to internationally. So we're seeing people using European human rights, in particular Article 2, the right to life, as a way of basically doing a sort of judicial review of the government, linking Paris agreements and things that they've signed up to and keeping them to the promises that they have kept. So that's happening, and that's very interesting that international law is usually being used by domestic courts. We also found a recent decision out of the Dutch courts, a case called Milieu Defensie, Friends of the Earth against Royal Dutch Shell. And that was also a case that was where the Dutch court found that that multinational had a legal duty of care to cut its emissions by 45% by 2030. These are very far-reaching obligations and findings. I think they turn on some of the peculiarities of Dutch law, and the fact that in many of those systems, international law is directly applicable. If you're going to replicate that in the United, so for example, in the United Kingdom or in the Commonwealth states, the issue of dual legal systems come up, even though the CCJ has been moving towards a more fused approach to common law and international law. We also see, for example, in Australia, there's a case which brought to head the intergenerational dimension. And this was a case brought, I think it's called Ree Sharma, by a child by her next friend against the minister who was going to take actions to, I think, approve a coal plant. And that was, again, a sort of, administrative law principle and type of litigation going on, obviously with international law in the background and with duty of care and negligence elements in. So I think activists are being very, inventive. The courts are stepping up. As Lisa did rightly say, they're using international human rights law. They're using international environmental law insofar as they can, and also mixing in administrative law and elements of private law. Another example I can think of is the Human Rights Commission of the Philippines, which very ambitiously summoned a bunch of oil majors on the basis that they had a direct responsibility and could be put on the hook for climate change. So that was a very ambitious approach. My eyes were raised because of a lot of challenges about jurisdiction, etc. None of those multinationals were based in the Philippines. But what you see are people questioning some of the things that we hold dear in international law, right? because what climate does is to challenge the very state-centric nature in which international law is based. And so I think we're going to be trying to rethink very fundamental aspects of that. But that is what I think fundamentally makes international law at best a very, not holding at the moment much, transformational promise. I think it can help us along the way, but I don't think we could say that the solution is in the present system of international dispute resolution. And that's for a number of reasons, because the system of international dispute resolution is largely driven by states. Only states can approach International Court of Justice. Only states can approach the International Tribunal for the Law of the Sea, and the same political problems which bedevil the Paris Agreement and COP, those are also the ones that we face in the context of international dispute resolution. And what we are seeing also is a fragmentation. I mean, obviously, activists are trying to get a win anywhere they can, and hopefully all of these developments will coalesce into something very positive and try to cement the system of law. But we're at a very nascent stage, and international law is still a bit of virgin territory. Not one of the regional human rights bodies have really issued a climate change decision. Domestic courts have gone much further than, for example, the European Court or the Inter-American Commission or the African Commission, for that matter. So we haven't been seeing that. We would have all seen Vanuatu's putting down the gauntlet and stating its intention.
Yeah, I was about to get to that. Yeah.
Yeah, an advisory opinion. We've been here before. Palau tried in 2012, I think. It also stated an intention that didn't go anywhere.
And Vanuatu in 2011, yeah.
Yeah. Mm-hmm. So we can see. The question is, what role does the Caribbean play in that? In that process? Obviously, if Vanuatu will need the support of all states. AOC, everyone in AOC, and bigger, right? We need the majority to get it through the General Assembly. And that is going to be a big problem. And I come to this separately because that raises the question whether the International Court of Justice is achievable at this moment, whether there are other national forums that need to go first to keep building the momentum.
Yeah, so it's interesting that you stop at that point, because I suppose I want to ask two questions which are interrelated. As you said, and I kind of interjected, this is not the most recent expression of intention, I suppose is the best way of looking at it, by Vanuatu. It's not the first time a Pacific state has kind of made this posture. We've had Palau, we've had Tuvalu, and as there are challenges. So I guess my question is, one, is there a forum internationally which may be easier to, because essentially what Vanuatu and Tuvalu and Palau want is an advisory opinion, which in itself may not be will not change. Well, I wouldn't say it wouldn't change, but it's an advisory opinion. But of course, it may be the beginnings of the opening of the floodgates. But as you rightly mentioned, there are a lot of ifs, buts, and maybes to get there. Is there an international? Is there other possibilities internationally, and apart from the human rights councils and so on, which have been, as you said, making also making their contribution with limitation? And the second part of the question, can we in the regional, using our regional international law, perhaps be the ones, I suppose, apart from the Europeans, to make the first step or the advances? Sorry, I tend to, when I start thinking of a question, I think of another. So I apologize. I see you're scribbling down, but you can ask me to go back.
No, absolutely. So what is attractive about the International Court of Justice is that it has very broad jurisdiction, right? You can ask it very abstract questions of public international law. And so what is envisaged is that request for advisory opinion would straddle all the areas of international law. You'd get an omnibus decision which would touch on human rights, international environmental law, customary international law. We could talk about, the court could do something very innovative, talk about the duty of cooperation between states, transboundary harm, a lot of those legal principles that we're trying to use to develop, for example, what Lisa talked about in the area of loss and damage, the legal principles that are needed to sort of boost and to undergird those new developing areas. You could have the court look into that because it is not limited by an instrument. And so that's what is very attractive. But of course, with that power comes then the political safety valve, which is that you need either the Security Council, which will never happen, or the or the General Assembly to request the decision. The other international body that has been mooted is the International Tribunal for the Law of the Sea. And that's a very interesting one. Of course, it will be a very limited, not a very limited, but it will be a more limited advisory opinion. But there are very important aspects that an advisory opinion from ITLOS could address. Definitely seawater, sea levels and the obligations of states and the rights of coastal states. For example, loss and damage, right? People's territories being completely disappeared. The slight wrinkle with the ITLOS advisory opinion is that the regime around ITLOS advisory opinion is not clear. And I think in their rules, and I think it's Article 138 of their rules, say that they can give an international opinion if there is an agreement, an international agreement, which is related to the purposes of ITLOS, UNCLOS, which allows the parties to submit a request for advisory opinion. So at the moment, we do not know of any existing agreements which allow that. But what ITLOS has done, I understand that it has signaled that it's taking that provision very liberally. It's going to interpret it very liberally. So in theory, CARICOM could conclude an agreement which falls within this and make provision for an advisory opinion and to seek that opinion pursuant to that agreement. In theory, also, you could have a bilateral treaty. 2 states could do it. Whether that request would have a lot of international legitimacy is another problem, but it seems to me that there could be a way of engineering a request from ITLOS in this way. And, a very important element of the climate justice agenda could be addressed, albeit solely within the lens of the Law of the Sea Convention. So that is something that I think people are thinking about. It's seen as the sort of plan C. No, I actually think it's very, very, it's very, very important and should be thought through much more carefully. And I've been, if I confess, I've been trying to workshop this with people in the region and certain leaders. No one's taking me on. But it would be a very interesting thing to develop. As to your second question about regional international law, that would have to be in the context of, I think, CARICOM, and I'm not sure. I saw a question, and I know you come to the question about, Caribbean countries, living up to their own international obligations in this area, while also trying to exploit certain natural resources that they've come into. So we'll have to see where that goes. My hope is that Caribbean countries will either help Vanuatu insofar as we can help and push that agenda, or really take seriously the Law of the Sea Convention. And I think there are a number of connections to the region in that where we can own it. Obviously, the Seabed Authority is in Jamaica. I'm a boy from Montego Bay. I'm very proud of the Montego Bay Convention. But on top of that, we have a Jamaican judge on ITLOS. So there are also, regional affinities that, you know, make that perhaps a place that we want to go to. So, you know, I think that we should put our heads together. I'm not sure where the political will in the region is on this and who is standing up and saying we need to move forward. My impression is that some are willing, but everyone wants to move in step. And I fear that actually somebody's going to have to move ahead of the pack.
Yes, an excellent concluding statement indeed. And I'm happy to say I'm not the only one who refers to UNCLOS as the Montego Bay Convention. I remember submitting a paper and they corrected it and I was like, Montego Bay Convention. I'm from the Caribbean. Yeah, certainly fascinating points you've raised. And as you were speaking, I was checking part 12 of UNCLOS and wondering if perhaps it could not, if perhaps within there a basis could not also be found. But certainly, I think we need to have kind of like how in the Pacific you have the Palus, Vanuatus, Tuvalus. Somebody's gonna need to say, hey, and certainly in terms of while the jurisdiction and the scope of ITLOS's advisory opinions is not perhaps as clear as the ICJ. Again, our Pacific states did take and request from ITLOS an advisory opinion on part 11. It would be the area deep sea bed mining, and you know, and I think as fate would have it, that kind of pushed international action on developing, because part 12 was, part 11 had kind of sat there. We have the Seabed Authority in Kingston, but nobody was, you know, there were a lot of rules that needed to flesh out. And then I believe it was Tonga, is it? That took the advisory opinion because they want to grant licenses to person. And suddenly a fire was lit. So maybe that's the approach we're gonna have to take. We may not be able to get to the ICJ, but we're gonna maybe get to start. And while I do think, for example, the human rights, the moves on the human rights treaty, so like Titola, the most recent under the Council of Human Rights, the potential of these decisions, you know, in terms of intergenerational equity. So while I read the decision with a bit of dismay, I looked at it and said, you know, maybe this bodes well for intergenerational equity, especially when you have, so for example, I know currently the European Court of Human Rights has a case from some youth, which basically hinges on the principle of intergenerational equity. And maybe our regional courts may soon be seized with these issues. Well, perhaps what I can segue to, and then we'll circle back to Conway and Lisa. I like to get Justin in on the discussions, because as we're speaking about the Pacific, and so we're speaking about a region of the world which you're closer than we are, Justin, at the moment. only by strict geography, right? So we've spoken about the Kiribati states such as Vanuatu, Tuvalu, and Palu, and basically what we're seeing is a potential shift in approaches in addressing the impacts of climate, of how we use law, including international law, in the pursuit of climate justice. So one of the I suppose developments that it has been quietly developed, and I probably say quietly but we're about to discuss it, so maybe not so quietly anymore. More at the national level. So we've seen examples in New Zealand, and what I'm speaking about is granting personhood to features of nature. I remember when I was an undergraduate, reading a book for one of my environmental courses called Do Trees Have Standing, right? I forget the author right now, but very happy to see in recent years. So we have, I'm not going to even try to pronounce that, but a river in New Zealand. We had Lake Erie in the US, state of Ohio. We've had the Rio Trato in Colombia, the Ganges and the Yamuna in India, and all the rivers in Bangladesh. I thought that was quite, so this is the attributing personhood to these natural features. Can you briefly explain what do we mean by attributing personhood and how these illustrations link with the concept of earth trusteeship?
All right, thank you. Thank you, Alana. And of course, I thank my fellow panelists for their statements as well as their contributions. This well, I think, known topic, which we are in a sense trying to relearn and push forward an agenda. Well, I'm going to speak very quickly about the rights of nature, but I just want to bring it into some context first in terms of the connection with climate justice. For me, climate justice is justice for the vulnerable, basically, to put it in a nutshell. And when I say the vulnerable, we're talking we saw cases with children, we saw indigenous persons, the aged, and these are the persons who are least contributing to the warming of the planet. You're right, I'm now here in the Pacific, and this is where all the rights of nature, well, it really started, the birth of the rights of nature, if I would say. And it is interesting because when you speak about, I always tell all my friends here in New Zealand that the Caribbean is just like the Pacific, but the next side of the world, which is the reality of it. The Pacific Ocean is probably is the biggest ocean in the world, but we are just, I mean, I've visited some Pacific islands. New Zealand is a Pacific island. Most people do not know, but albeit a big island. Like Trinidad and Tobago.
So is Australia. But...
Yeah. Well, Australia, that's out of the league. That I actually consider that a continent. But you have countries like, as we mentioned, Maldives, Tuvalu, Kiribati. These islands could virtually disappear in the next, you're talking about 2, 3, who knows, maybe in a few months, few years, I mean, we hope not. So these states, what will happen when we're looking at, people already starting to say, we are going to see a demise of sovereignty, where there are just no more states anymore. Or if we don't see a demise of sovereignty, what will actually happen? People have actually been saying that, is that these states will become deterritorialized states. That being said, is that their seat of government would be in another country, because they're disappeared, there's no longer a country. Their seat will be in another country. So you can imagine, we're talking about the Bahamas. I saw Lisa about the Bahamas. So you can imagine if there are no more islands in the Bahamas, or no more, any island in the Caribbean, Trinidad and Tobago, Barbados, wherever have you. You could imagine the seat of our government being in Washington, DC, for example, because our state just doesn't exist anymore. So these are things, of course, these are things that we have to think about. In the Montevideo Convention, you can't have a state without territory or population and so on. But these are things that would probably be the reality. They would have states, seat of government in another state, a big country. But that being said, the rights of nature, so this is just the context with the rights of nature. New Zealand, of course, is the famous example. Everyone, most persons know about that, the Whanganui River. I hope I got the Maori pronunciation correct too, Alana. Whanganui River. There was a legislation that was passed in 2017 by New Zealand, and this river is of spiritual importance to the first people of New Zealand, which is the Maori. And these negotiations did not happen overnight. It's actually called a settlement treaty. That's a full name, Whanganui River Settlement Act, sorry. And these negotiations have been going on since the Treaty of Waitangi 1840. So it's actually centuries, and it actually became a reality. It's 1840, almost 200 years. And they finally came to a negotiation. The Maori saying is that I am the river and the river is me. All this is in the legislation. There's actually the Maori language in the legislation. So it's a mix of English and Maori. And what the government has done is that they have said that in the legislation, they said there are two persons who will be the face of that river or the guardian of that river. And one will be appointed by the Crown. Well, when they say the Crown, the government, because New Zealand is still a Crown colony. Well, it's still a Crown. They still are not republic. They're not a republic. So the Crown is still the head of state. And one person is appointed by the Maori. So this is the first time you have a treaty or partnership arrangement between one indigenous group and a government member actually overseeing a natural space and being a guardian for natural space. And this is the first time you've actually seen something like that. If we go on, I mean, there are a plethora of cases on this. If we go to India, India did the same thing as soon, just like a few days after New Zealand passed their act. India, their high, but it was not an act, it was the High Court that ruled that the Ganges and the Yamuna River are considered legal persons. And this is because of the spiritual reasons for the Hindus. And in some cases, the Ganges is known as a deity, of course. Then we have Bangladesh. You mentioned Bangladesh, where they did completely the opposite to New Zealand and India. They said all the rivers are considered legal persons. And this is the High Court again. This is not legislation. This is the High Court ruling. And going back to climate justice and the vulnerable, we have to take that in context of what exactly is the situation in Bangladesh, the current geographical situation. A lot of people don't know Bangladesh is one of the most populous nations in the world. 166 million people. They are, in terms of geography, they have 700 rivers, deltas, tributaries. They are prone to flooding, cyclones. So that decision was made in that particular context. And what is very interesting about that decision is that the court directed that the Minister of Education actually ensures that there's a curriculum in schools from primary schools to university levels teaching about the rights of rivers, the importance of rivers, why they should be preserved. Of course, that was also innovative, I would think. But you still have to consider how are they going to actually control, and I know this will probably be a question, how are they going to actually control or make sure that these rights are being respected? They have a National River Conservation Board. They set up as a local parentis, which is basically like the guardian of this particular river. Then we speak a little bit about Colombia, closer to home. Well, not where I am, but in the region. And Colombia, their Supreme Court ruled that, and this was an action, first of all, by 25 children, youth, because I think the eldest was 25. So I think the age was 7 to 25. And they were actually approached the court for, they said that the deforestation in the Colombian Amazon forest, rainforest, was a breach of their rights to healthy environment, rights to life, right to health. And the court actually ruled that the Amazon rainforest is the subject of rights. And they actually said in the, I mean, you don't hear courts saying these things in certain parts of the world. They said that the Amazon forest is the lungs of the world, basically. So, you know, it gives that kind of metaphor, which we all know when we read that in primary school books or maybe National Geographic, but you have a judicial decision that's saying it is the lungs of the world, a judicial pronouncement. And what is actually quite fascinating, I think, also in that case is that they said that there was a breach of the constitutional right for the children, the present generation, and the future generation, including generation that is unborn. And this goes on, of course, to intergenerational rights, which we were speaking about. Conway spoke about Australia, so I wouldn't need, that was a recent decision, and we brought in some law of tort language where they said that the minister has a duty of care to children in terms of climate matters that would be adverse to children's health. So that was interesting because you saw the tort law duty of care and negligence coming into a climate change action. So now we're getting into Earth trusteeship. I just want to touch on that a bit. So the right of nature is intertwined with Earth trusteeship. Well, you see climate justice, rights of nature, Earth trusteeship. But Earth trusteeship, a component of Earth trusteeship that I want to speak about is the atmosphere. Now, the atmosphere is something that if you ask someone who owns the atmosphere, just as you ask someone who owns the Earth, the right answer would be no one, because you would think that nobody could own the atmosphere and nobody could own the Earth. But we all have a duty to hold the Earth or the atmosphere in trust for the future generations or the present generation. So this is something that they call the atmospheric trust. It's a new principle that is coming out, especially in American jurisprudence, in the public trust doctrine. And when I'm speaking about the atmosphere, it's important because you have the WHO saying that 7 million persons a year, if you go on the website, you see it, 7 million persons a year are dying from air pollution, right? Now, I'm not a COVID or pandemic skeptic or anything. I'm fully vaccinated, right? But when you compare, I looked at the data yesterday. Yeah, I'm just showing out there. I looked at the data yesterday, and we're almost in the pandemic for 2 years, and we have 4.5 million persons have died from COVID-19, the pandemic. And we do, of course, we sympathize with that. COVID is real. If you haven't gotten vaccinated, I implore everybody to get vaccinated. But why isn't environmental matters more mainstream? For example, as I said, 7 million persons die every year from air pollution. If it's from lung cancer, heart disease, yeah.
And I think the WHO recently published a report to this effect. Yes.
Yeah. So these are kind of things. That's why we have persons like Greta. We have a lot of Extinction Rebellion marching on the streets. We have to give these things notice. And there was another case coming out of Indonesia as well in September, where the court ruled that the government should take more consideration for the Jakarta residents because of the air pollution, the debilitating air pollution. So they have to do things to secure that. Yeah.
Yeah. So I've been jotting down as you speak, and I think also maybe it has me also thinking about what Conway was thinking too. So some of the points I've jotted down here, it seems that in many of the what we would term from a legal perspective or how the law has contributed or can contribute, we see it a lot so you mentioned tort, for example, in the Australian case, and there are a lot of public law concepts coming out. I know certainly when you talk about the right to health, I know, for example, in Trinidad and Tobago, there was a case of Sobion against the Attorney General, again, trying to link the right to health, for example, to that in constitutional rights. So that's one observation I make. I also note that it seems that a lot of this is being driven by the intergenerational nature or the intergenerational impacts. Maybe we want to look at it that way. But I still, as the devil's, let me play the devil's advocate and say, a lot of what we're speaking about, the human rights approach, Earth trusteeship, someone who's cynical might say, these are utopian and can they really contribute to the future of climate justice? Perhaps you want to weigh in on that.
Yeah, definitely. Well, Earth Earth trusteeship is a very broad spectrum. I think it's definitely the future, Earth trusteeship. Now we're talking about, you know, some persons, we have the climate conference, but the Earth is not only comprising the climate, right? I mean, climate, yes, is important, but there are other issues, the oceans, the soil, the biodiversity, the glaciers. We talk about the chrysosphere, the biosphere, the lithosphere. So we're looking at the Earth as one single organic system, a complicated system that works together. Actually, the Earth is a living planet. I mean, it's the only place in Earth, well, for now, until NASA or some other scientists discover another planet with life. But it's the only thing of it. We are the only place that is, quote unquote, discovered where there is all these life forms living in abundance. So what Earth trusteeship is saying is that, okay, hold on, we're not going to hold the atmosphere in trust. States are not going to hold the climate in trust for the future generations. Why don't we hold the entire Earth or consider it a legal, not even a legal being, but a living person? Because all of us are dependent on each other. We are all interrelated. We are all interdependent. So that's what Earth trusteeship is about. And when we talk about these climate negotiations, I know I have a lot of friends who are very advanced negotiators. Rueanna, for example, you know, Lisa, I understand, has been involved with it as well. But I also do have some reservations with after all these years, because like my supervisor could say, right, you can't negotiate when rain going to fall, or when a hurricane is going to come, or when an earthquake will hit you, or when the sun is going to shine. Nobody can negotiate that. And I met some locals here, and we're talking about it. It's almost like we're saying climate prayers, really. Like, it's like you're hoping for something, and you know, you're not even going to hoping that something will happen when it won't. So we need what, I mean, as I said, we have a lot of dedicated and skilled negotiators out there, but what we need is we need political will at the end of the day. Because it's the states that really draw all the cards. It's the states that have to make we can negotiate how much you want. And it's like negotiating for when the rain will fall or when the sun will shine. And that's how I look at climate negotiations.
Okay. Yeah. And perhaps this is where the intergenerational element may eventually be the critical, you know, turning point of the day. And my comment on other planets, at the rate we're going, we'll have Jeff Bezos or Sir Richard Branson on another planet. My thoughts are, let's try to get it right on Earth first before we go and corrupt any other civilizations out there. But okay, on that note, we can turn to, we have some fascinating questions being posed to our panelists. So perhaps I'll start with a question that is directed at Conway, and then we'll, as a panel, we'll see how many of the others we can get through before we wrap up. Okay. So the question to Conway is your comments in relation to using the ITLO's advisory opinion as a starting point for getting broader consensus on these issues is interesting. And sorry, I forgot to mention this comment is posed by my colleague, Ms. Nicole Foster, Deputy Dean of the Faculty of Law, and an international lawyer. So I smile when I see this. I note that a similar strategy was followed by Mauritius, read the Chagos Islands, with their linked ICJ and ITLO strategies. Counsel Philip Sands, QC, has had some interested comments from a strategic litigation perspective and how this linked into Mauritius's overall long-term goal in terms of reclaiming the Chagos Islands. Do you have any comments you want to offer, Conway?
Yeah, no, I think that Nicole makes an excellent point. I mean, my background certainly is in the area of strategic litigation. And so, what we do is we do incremental steps, right? We don't think litigation, there's going to be one judgment that's going to solve the problem. It's incremental steps, building consensus, building the law, thinking about the law as a very dynamic, a dynamic thing. Because we think that when you have change, social change is what we're looking for, right? What we're talking about is social change. Changing the minds of people or actions and having us act in a certain way to preserve life on this planet. What we do need is pressure from above and pressure from below, right? We have the grassroots movements, we have the people and the activists who are fighting in the domestic courts, who are trying to raise consciousness and to develop the law at domestic level. What we need is also something at the international level, and hopefully those norms will converge and we'll get to see something along the lines that Justin is talking about. I completely agree with Justin that the present way that we think about international law and responsibility is outmoded. International responsibility based on a state or one state having responsibility because they did X or did Y doesn't fit within climate change. Because one of the problems you have as a litigator, we can say, is going to be proof, right? How can you prove who did it? And of course, this is what IOC says. It says, we're not responsible. We're responsible for only 1%, but yet we have the bulk of the burden. What we're going to have to do is to move to a model of international responsibility that is based on solidarity or trusteeship or common heritage of mankind. We already have started to articulate these ideas that if you do something wrong, or if you don't act, if you omit to act, you're killing us, right? So, that's where we need to get to, but that can't be done by a court. That needs to be done through lawmaking. But at the moment, what we have are these levers. And I think we should be using them to try to get everyone to a place of understanding that international law is necessary for coordinating action, whether it's negotiations, the biggest challenge for climate change is coordinating actions, right? Everyone is presently dismayed because they're asking, is China going to turn up at COP? There was a question, was Australia going to turn up? It's a collective action problem. And one of the things that international law does is to help to coordinate, right? To ensure that everyone acts in step through norms and expectations. And we're going to have to try and push that. And if that's through strategic litigation, if that's through thinking about new ways of thinking about responsibility using concepts of trusteeship, whether it's litigation, all of these different levers, I think, move towards getting us to where we want to get to.
We'd like to be. And in terms of, well, per the paper, Australia seems like they will, at least the Prime Minister has confirmed that he will be at COP26. So let's see how that goes.
I just want to interject a little bit, if you don't
Go
mind,
ahead,
Alana.
Lisa.
So Justin threw a little shade at the negotiators, and I have to respond to that. Because I have to say at the outset, I agree entirely with Conway's approach that we need all of the above, we need all the strategies we can get with international law. I entirely agree that biodiversity has not been given the prominence that it should be given in terms of negotiations and international relations. There's a lot of focus on climate change. I do need to pick up our AOSIS negotiators though, because what Rueanna does and what I used to do, it is hard work. And we are small states, and we are outnumbered and outgunned, and it is late night.
David and Goliath, isn't it?
It is hard work, and you are up against countries that just are unwilling to move at all. And as SIDS, we have no money to give, we have no emissions to leverage, we have nothing. All we have are these negotiators that show up on a consistent basis and argue as best they can to at least give us something like a framework like the Paris Agreement, where we could make some movement and some action. And so I want to push back a little bit on what Conway has said as well. There's really only 15 to 16 big states that if they did something, they are responsible for the vast majority of emissions. And so it's really the UN system is very problematic to work through. It requires consensus. It's really hard work. It takes a long time, but there's really only a few states that need to move. And if they did something dramatic on emissions, and if in addition, the citizens in those states push their governments, and we see this a little bit more with young people, which I think is really hopeful. But, you know, if those citizens really pushed their government and voted to make dramatic change, we could actually see a lot more and faster progress. It's not going to fix everything, but we could actually see a lot done. So, you know, I do want to just make those two plugs.
Which perhaps segues, we have a question from Kendall Alexander, which I think will close the circle on that point you were mentioning. And perhaps, as you said, in many countries, in the issue of an environment, certainly not, you know, it's climate change, but now increasingly, as you said, biodiversity, because the flip side to this is a lot of biodiversity is disappearing, and a lot of it we're now realizing has economic benefits. And of course, we're facing the COVID-19 pandemic, which has links both to biodiversity and to climate change. So we're kind of stuck in a vicious cycle, and maybe perhaps shooting ourselves in the foot. So Kendall asks, so how do vulnerable countries and low-lying islands stand to hold larger countries and polluters / CO2 greenhouse emitters accountable? Because we see large corporations such as Volkswagen being held accountable and to reduce their emissions, but how do we get countries like the US and China to comply? And I guess that's the million-dollar question. And this would probably, we could probably wrap up on this, and we can continue the conversation offline, because I know there are several wonderful questions, but our time as a panel, and I want to give everybody a chance to give some final words. So anyone wants to comment on that? I see Lisa.
Justin's going to hate my answer, but I'll refer to the Paris Agreement and what we agreed or didn't agree to the Paris Agreement. And there's a compliance mechanism in the Paris Agreement under Article 15. Rue and I were there trying to negotiate more ambitious structures for that. It does have some elements of transparency, but basically the compliance mechanism in the Paris Agreement is very weak. And the reason it's very weak is because parties didn't agree obligations of result, which is what I referred to. They agreed obligations of conduct, procedural, like file your NDC, upgrade your NDC every 5 years. So compliance mechanism is very weak, but what parties did focus on is transparency. So there are very robust provisions on what countries are doing and what they're not doing. And therefore it really is sort of a name and shame process. Other than that, so that's the Paris Agreement itself. There would have to be other efforts like the one that Conway talked about with the ICJ and perhaps under UNCLOS that are possibilities.
And I think one of the potential, and I'll end up end up before I throw it back to you guys. One of the potential implications of the case currently in front of the European Court of Human Rights, it will have implications not only in European states, but for, you know, it would have an extraterritorial effect and impact on, you know, companies and so on, because one of the things that Rueanna had mentioned is the area of international investment law and how it you know, it's developed to protect investors, but what about the converse, right? So this may be a circular way of addressing it, because it means you can't necessarily move offshore. But we'll stick a point there and see, maybe when we do part 2.0 of this panel, we'll be able to see how that decision has panned out. So in the final minutes we have left, I just leave you, I just allow you to give it, you know, any final thoughts you have to conclude the panel, and then I will hand the reins over to Chantal, who will do the closing remarks. Who wants to go?
I'll go first, so that Lisa can correct me. No, I'm just kidding.
I'm a woman from the Caribbean. You can't ask me not to. Should tell you might be.
So the point here on international law, this is international law 101. People, there are still skeptics who question whether international law is law, because the people who are subject to the law, the people who make the law. And that's one of the fundamental constraints of international law. So the question is, how can you hold big states to account when they're the ones who write the rules? And that's that's a conundrum for progressive international lawyers, right? How do you get someone to bind themselves, continue to bind themselves? And it's to make them aware of enlightened self-interest, right? It's this idea of enlightened self-interest, to have the states recognize that in binding themselves, what they're doing is ensuring their survival. And I think, though, that this is where international lawyers need to work hand in hand with domestic activists, because what Lisa said is right. When we think of international law, we think of a state, we think of a unitary unit, right? But what it is the people. The domestic is the global, and the global is the domestic. So what Greta is doing, what the activists on the ground are doing, the domestic litigation is as important to the international lawyers, because that changes the moods in capitals. That then changes what happens in the negotiations, and that what comes and forms, the basis of our treaties. So what I'm saying is the multi-pronged approach, both local and global. And hopefully, if we are coordinated and we're moving in tandem and not bickering or working at cross purposes, we'll be able to move the needle both internationally and domestically.
Thank you, Conway. Justin seems to want to go next. So Lisa, that default, will have the final word. Go ahead.
Yeah, I just want to make sure that Lisa has the final word, so she could probably correct something that I say. No, but Lisa, yeah, I think I understood what you've said with respect to great credit have been, of course, to AOSIS and small island states, CARICOM and so on, negotiating. I'm also ukura with what's going on through Rueanna, because we always have these discussions. But my point was that I think that in the climate change negotiations, and just like any form of negotiations, if it's fisheries, trade, intellectual property, sometimes it feels like the small island states are just banging their heads against a wall, because the bigger states tend not to move their positions. So that was what I was really referring to. But generally, just to sum up my own contributions, I think for the Caribbean, we are definitely lagging behind as a region in terms of having that constitutional right to a healthy environment. And I was doing some research, in all the 15 CARICOM states, there are only 3 states that actually have that right. And well, 2, well, you should say 2.5, because I say a half because Belize has it in their preamble, but we all know preamble just tells the story of the Constitution. So the main ones are Jamaica and Ghana. And of course, some people say, okay, you just have it there in your Constitution, and what can you do? How we can enforce it? But the Constitution is a reflection of the minds of the people. So I think it's important to have that enshrined, because 2/3 of the United Nations have that particular right in their constitutions, and we comprise that latter third of those nations. So I think it's important as a principle. That is the foundation to start, because you say the Constitution is your founding law, or foundational law. So that is how I think we should start this whole, and that will trigger the issues with respect to climate justice.
Thank you, Justin. That we can have an entire conversation on that, and but certainly we'll have to do that another time. Lisa?
I just wanted to thank my colleague. It was a real pleasure to be here with you today. I really enjoyed the discussion. I do want to echo and agree with Justin on the constitutional issue. It's hard to update constitutions, but it's an exercise we should do, because our constitutions arguably were not really indigenous to our countries. I also think on policies and mechanisms domestically, Caribbean countries could do a lot more in terms of including loss and damage and issues of climate migration, although I agree it's very sensitive. And I want to make a point that we haven't discussed very much on climate finance. All of this is underpinned by the need for climate finance from wealthy countries, that's developed countries and large developing countries, and not only in terms of specific finance, but that's not loan based. I mean, we already are highly indebted in the Caribbean, so we don't need more loans. It's really money that we could use to actually implement projects on the ground within our countries to take action now, because there's been a lot of talk about loss and damage and climate finance, but no real implementation. So I'm hoping to see that in the near future. But thank you, Alana, and it's great to see everyone. Thanks for having me.
Thank you, and I have to, as I was saying to Chantal, we're now getting warm, but we will pick up on this another time, because I think the point I think on the point you ended on circles back to our first panel, and we see that there's a golden thread one way or the other running through the 3 panels. So thank you, everyone. Thank you for a wonderful panel. Thanks to Stefan and Sanya. I'm sorry, apologies, Sanya, I did not mention you before, but Sanya's been providing back our assistance with the question and answer. And I now hand over to Chantal for the closing remarks.
Thank you so much, Alana. We've really come to the close of a very stimulating conference. It started with a brilliant keynote address delivered by Ms. Merland Price, and our panels on sustainable investing, health resilience, and climate justice really took over the mantle and conducted a deeper dive into this important question of what role can international law play in securing justice and resilience for the Caribbean. And we've had some very interesting perspectives shared on what are the prospects and limits of international law in this regard. Our sustainable investing panel delivered some very empowering messages. We heard about trends towards incorporation of environmental, social, and governance factors into investment decisions in the region, and a call was issued for the deployment of even more risk capital in this area. There was even talk of the development of ESG-related standards at the regional level. Our panel on health resilience provided even more texture as to how international law, whether it's human rights law, international intellectual property law, international trade law, how it has provided a framework for essentially the balancing of competing interests or considerations that are at play when public health issues are addressed. And we've certainly heard from our panel on climate justice some very sobering messages, even about the irreversible damage that the climate crisis can generate. We've heard about the limits of the current state-centric focused orientation of international law in addressing as significant an issue as the climate crisis, but very importantly, we've also heard about the possibilities for how international law and international cooperation can facilitate coordination to address this important challenge. I'd really like to thank all who have participated in this conference, in particular our attendees, some of whom have actually been with us since the beginning. And I'd like to extend special thanks to all of our speakers. As I said, our keynote speaker, Ms. Merland Price, the brilliant speakers we've had on our panels on sustainable investing, health resilience, and climate justice. I'd really, really like to thank our very able moderators, Nicola Berry, Gladys Young, Alana Lancaster, our rapporteurs, Stefan Newton, Pierre Cook Jr., and Max Ron Holder, and our Q&A moderators, Camille Adair Morgan and Sanya Aline. And again, very special thanks to our planning or organizing committee for the conference. Again, Sanya, Nicola, Justice Gafour, Alana, Dr. Jean-Yves Remy, Gladys Young. And I have to extend very deep appreciation to our virtual host, Akeem Greenidge, as well as Jermaine Atwell. Both of these gentlemen worked tirelessly with us on promotional material and the IT arrangements for the conference, which included navigating through the waters of Zoom events. And just to advise everyone, we will be making available a report of the conference, as well as a recording of these very stimulating discussions that we have had. And the conversations were so rich that it's clear that we have to take some of the conclusions and recommendations of the conference forward. Again, thank you to all our attendees who supported the event. We look forward to your participation in future events of the ILA Caribbean Branch. So everyone, thank you so much for your support and participation, and take good care and stay safe. Thank you.